Good day, Crime Talk aficionados. We have a great show for you. First, Bryan Kohberger secures a victory in the restitution dispute. Trial begins for the Ohio officer accused in the fatal shooting of a pregnant woman. An Athens, Pennsylvania couple is charged with severe abuse involving a toddler. A traffic hallway clash turns deadly. I don't know. Should we charge the parents as well? Murdaugh throws a little shade at Hulu's dramatic take on his family's fatal fiasco. And a former American Idol participant charged with some multiple felonies involving some alleged misconduct with a minor. A mile-high pair dodges the docket on our dumb criminal of the day. We've got our This Day in Legal History and our quote of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for watching. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment below and hit that little bell for notifications, all right? And don't forget to check us out on any of your favorite podcasting apps. Now, for one of our subscribers viewers last night, I was going through the comments. Hold on one second. Let me fix something for you. Apparently, the defending a federal criminal case slanting over apparently was driving somebody nuts. So I said I'd see what I could do. So now we tilted it the other way. Hopefully that'll work. All right. Before we get to the docket, let me remind you, go to crimetalksearch.com. Listen, if you're going to do a background search, you want to do a background search, you think you need to do a background search on anybody that's coming into your life, go to crimetalksearch.com. You won't be disappointed. You'll be happy that you did it. Listen, it's literally dating malpractice if you don't check somebody out. And we're not talking a quick Google search. No, you want a report that has searched thousands of public databases all over the United States, where you're going to find out if people are legit. Are they married, divorced? Do they have a criminal history? Are they on a sex offender registry? Everything you want to know about somebody, go check it out. All right. Also, go down to the link below if you want some Crime Talk merch. Told you after CrimeCon, I had lots of people asking about merch. Stuff has been flying out the door. I'm quite impressed. So if you haven't got yours yet, please do. And hey, if you got a suggestion, let me know as well. All right, let's go ahead and open the docket for Wednesday, November 5th, 2025. And first on the docket, Bryan Kohberger. He secures a partial victory in the restitution dispute. So in a recent court proceeding, as early as today, you can take a look at it if you don't believe me. All right. But in the 4th District Court, the attorneys representing Bryan Kohberger successfully challenged a $27,000 restitution claim, leading the prosecution to withdraw it. Now, this development marks a limited success for Kohberger, who was convicted, obviously, of multiple murders amid ongoing debates over financial obligations to the victim's family. Now, during the hearing, the lead defense attorney for Kohberger argued that Kohberger should not be required to pay the specified amount, noting that the families had already raised substantial funds through crowdfunding platforms to cover travel and lodging costs associated with the case. The prosecution, represented by Bill Thompson, acknowledged an error in its initial interpretation of the plea agreement and conceded that such funds could not be allocated for victim reimbursement in this matter. Consequently, Thompson formally retracted the request for the $27,000. Now, Thompson countered that the defense assertion of Kohberger's financial incapacity by pointing out the external contributions had been received and that the future earnings could potentially enable payment. Now, in response to that, the attorneys for Kohberger emphasized that projections of future income were purely conjecture and maintained that Kohberger currently lacks the means to fulfill even modest obligations, such as approximately $3,000 for future funeral-related items, which included urns as stipulated in the plea agreement. Now, the presiding judge indicated that a formal ruling would be issued in the near future following the intense exchange. Notably, Kohberger's legal team is not disputing other financial penalties outlined in the plea agreement, including the $250,000 in criminal fines and the additional $80,000 distributed equally among the families of the victims. Now, the contested $27,000 was intended specifically for travel expenses, with $20,000 allocated for the Gonsalves family and $7,000 to Madison Mogen's mother. As background, obviously, Kohberger entered into a guilty plea earlier this year to 4 counts of murder, a decision that he made to evade the possibility of a capital punishment, i.e. the death penalty. This arrangement has drawn, obviously, some criticism, particularly from the affected families. And since his conviction, Kohberger has been incarcerated at the Idaho Maximum Security Institution in Kuna, which is near Boise, Idaho. Reports indicated that challenges in his confinement, including claims that he was being verbally harassed from other inmates alongside a highly restricted daily routine limited to 1 hour of recreation time outside of his cell. So here's the interesting thing about the hearing that I think is worth also noting. The judge, not exactly particularly impressed with the prosecution as it relates to the withdrawing of the funds, but realizes the statute reads as much, which we talked about just the other day, that they probably weren't entitled to that money. So I guess I called it correctly. All right. But the issue then becomes to the ability to pay. And the judge is like, hey, it looks like the family's been paying him money. He's going to get other sources of money. Why can't the state then draw money from his bank account while he is in custody? I shouldn't say bank account. Let's use his commissary, his books. All right. And I think that's what the judge is going to do. And he specifically said that, there's a plea agreement. So the judge asked, is the plea agreement not valid if you guys didn't agree to the terms? It looks like you agreed to the restitution. Why should we not enforce it? The defense said no. Prosecution was like, well, we want our plea agreement enforced. We just, we want him to pay. We don't want to withdraw any plea bargains in this case. That would be a complete fiasco. So I think ultimately the judge will rule that the state can basically garnish anything that comes into Bryan Kohberger's account while he is in custody in accordance with state law, and his inability to pay shouldn't be affected in any way to that. Whatever he gets over the years, who knows? Parents probably send him a few bucks. The state will pull off what they can. That's the law in just about every jurisdiction that I'm aware of. Next on the docket, trial begins for an Ohio officer accused in a fatal shooting of a pregnant woman. Opening statements commenced on Wednesday in the high-profile murder trial of the Blendon Township police officer, a guy by the name of Connor Grubb, who's accused of fatally shooting a 21-year-old Takiya Young, T-A-K-I-Y-A Young, and her unborn daughter during an encounter outside a Kroger supermarket back in August of 2023. Now, Mr. Grubb, who's 31, faces multiple serious charges, including 4 counts of murder, 4 counts of felonious assault, and 2 counts of involuntary manslaughter. Now, a conviction of the murder charges could result in a life sentence. Now, the proceedings presided over by Judge David Young, no relation to the victim, are anticipated to span 2 to 3 weeks. Now, a panel of 12 jurors comprising 4 men and 8 women with 1 juror of color and 4 female alternates, including 1 person of color, was impaneled following jury selection that concluded earlier this week. The prosecutors from Montgomery County, led by Aaron Claypool, Daniel Brandt, and Richard Glennon, are seeking to demonstrate that Grubb's decision to use lethal force was unjustified. Now, in the opening remarks, Glennon outlined the sequence of events, noting that Young had been suspected of shoplifting alcohol from the store. He emphasized that Grubb opted to position himself in front of Young's vehicle and discharged his weapon, despite alternatives available to de-escalate the situation. Now, Glennon contended that Young had activated her right turn signal and was maneuvering her car slowly away from the officer, allowing Grubb ample opportunity to move aside. He described the action as entirely avoidable and asserted that Grubb was not facing any immediate threat of his safety. Well, the defense, through the attorneys, Mark Collins and Caitlin Stevens, argued that Grubb acted appropriately in response to a perceived imminent danger. Stevens highlighted in her statements the law enforcement protocols authorize deadly force when an officer or bystander faces a risk of serious injury. She portrayed Young's vehicle, estimated at 35,000 pounds, as a potential lethal instrument capable of inflicting grave harm. And according to Stevens, Grubb's positioning at the front of the car was necessary to shield his fellow officers while minimizing risks to nearby shoppers. She further noted that the absence of a license plate on Young's vehicle would have complicated any pursuit if she had fled, potentially endangering others, including a child in the vicinity. Now, Stevens stressed that Young's choice jeopardized the officers, store patrons, and her unborn child. And she confirmed that Grubb intends to take the stand in his own defense. That's a big, bold move in opening statements for sure. The incident unfolded on August 24th, 2023 at the Kroger location at South Sunbury Road in Blendon Township near Westerville. Store surveillance video showed Young entering the liquor area and concealing several bottles in her purse. Shortly after, two other women approached her as she queued with additional items in a basket. Young then left the store with her bags, triggering an alarm, though she no longer carried the basket. Outside, a store manager alerted Grubb and another officer, who were assisted with a separate vehicle lockout in the parking lot, to Young's alleged theft. The officers then approached one of the driver's side windows, repeatedly instructing Young to exit the vehicle, which lacked a license plate. Young denied the accusations and engaged in a verbal exchange. As tensions rose, Grubb moved to the front of his car, drew his firearm, and placed a hand on the hood while aiming at Young. Body camera footage captured Young turning the steering wheel to the right and inquiring if Grubb planned to shoot her. As the vehicle began to advance slowly, Grubb was momentarily lifted before firing a single round into Young's chest. The car continued forward approximately 50 feet until it collided with the store buildings. In the aftermath, officers shattered the driver's window to extract Young, who was handcuffed. Medical assistance was summoned roughly 20 seconds later. Grubbs retrieved a chest seal from his patrol car, and an off-duty emergency room physician from Ohio Health intervened, applying aid. Despite efforts, including CPR initiated by officers, no pulse was detected. Paramedics arrived at about 12 minutes after the shooting, and Young was transported to the hospital, where both she and her fetus were pronounced dead. Throughout the response, Grubb repeatedly stated to arriving colleagues that Young had attempted to strike him with her vehicle. Obviously, this case has got a lot of attention because it involves police use of force, particularly in what could be argued as a non-violent theft scenario involving vulnerable individuals, as they say in the court sessions. Well, so we're live streaming this case. It's going to be interesting. You know, normally prosecutors' offices give great deference to police officers. It's going to be a question of fact for the jury to decide, did this officer act reasonably? And normally, you know, it's much different standard for civilians than it is police officers. Police officers are like, yeah, I felt threatened. Usually that's good enough. But the prosecutors in this particular case think that murder was committed and that the officer was in no danger whatsoever. It's going to be interesting to watch the trial develop. Next on the docket, couple from Pennsylvania. Yeah, not good. Let's just talk about it like this. Situation involving a toddler child that now has permanent brain damage. So this comes from Athens, Pennsylvania. Police have charged a local man and a woman with multiple offenses following an investigation into an alleged severe mistreatment of a 3-year-old girl under their care, resulting in irreversible neurological impairment. That's a fancy word for brain damage. Dalton James Sweat, age 26, faces felony counts of assault and child endangerment, among a bunch of other charges, as detailed in court documents from the Athens Borough Police Department. His partner, Alyssa Ray Kithcart, also 26, has been charged with felony child endangerment and a related misdemeanor. Now, the incident came to light on May 20th when police responded to a residence in East Frederick Street after reports of the child sustaining a head injury from a fall, rendering her unresponsive, yet still breathing. Upon arrival, officers encountered Sweat at the entrance and discovered that the girl was on the floor, semi-conscious with minimal eye movement. Observations noted apparent neglect, including visible waste in her diaper and an emaciated appearance. Emergency personnel services attended to the child while Sweat was interviewed. He explained that Kithcart had notified him of an accident en route to his workplace and confirmed her absence from the home at the time. The toddler was transported to a nearby hospital and subsequently airlifted to another hospital for care. Subsequent questioning of Kithcart revealed her account of the child slipping from furniture during preparation from school, landing near a coat rack. Anyway, she described the girl's demeanor as unusual but attributed to fatigue. Police documented the scene, obviously, with a bunch of photographs. Medical evaluations contradicted the provided explanations. Specialists at the hospital reported a fractured right clavicle, significant swelling on the rear left side of the skull, indicative of separate trauma, widespread bruising inconsistent with a single fall, and severe underweight status at approximately 25 pounds. Needless to say, child safety experts deemed the injuries incompatible with the described events, i.e., the parents were lying. Further inquiries uncovered discrepancies. Sweat referenced additional witnesses present, including one who allegedly assisted the child post-fall. Kithcart admitted concerns over Sweat's disciplinary methods, citing past unreported incidences of, maybe a little excessive severity. She also mentioned a prior airlift to the hospital following a stair fall. Fell down the stairs. Investigators obtained the suspect's mobile device after Sweats photographed the implicated furniture. A multidisciplinary review involved child welfare agencies, medical professionals, judicial officials, and investigators, highlighting the family reports of Sweat's aggressive behavior. Witness interviews corroborated patterns of physical aggression by Sweat. Kithcart disclosed his requests for her to fabricate accounts, which she refused. In a follow-up session, Sweat maintained his narrative, but implicated an unidentified party during a polygraph examination, which turned out it indicated deception. Additionally, family statements reinforced allegations of Sweat's volatility, with Kithcart expressing prior awareness. During her voluntary polygraph, she denied inflicting the injuries but affirmed her belief in Sweat's involvement. Two more witnesses described Sweat's forceful conduct and confirmed observing the May 20th fall. A judicial hearing on the child's prognosis revealed extensive brain damage with the left hemisphere non-functional and minimal prospects of recovery. Physicians attributed the conditions to repeated cranial impacts or a major traumatic episode, ruling out, that it was an accident. Kithcart later submitted an email detailing historical violent episodes by Sweat towards the child, and based on the accumulated evidence, both individuals were formally charged. Sweat is now in custody at the Bradford County Correctional Facility on a $1 million bond. Kithcart is being held on a $100,000 bond. Preliminary hearings are set for both today for November 4th. The investigation continues, and police are asking people that, emphasize the protection of vulnerable children. You think? And that's interesting. Most cases these days involve so much digital data. That's just good old-fashioned police work, right? Story doesn't make sense. Keep questioning them. The first version is never the truth. Trust me on this, ladies and gentlemen. The first version is never the truth. Anyway, there you go. Good police work. Obviously, give him the presumption of innocence. But Mr. Sweat I'm sure he's sweating it right now in his jail cell. Nobody wants to be a child abuser in jail, let alone prison. Hey, you ever bumped into somebody at the hallway? Well, teenagers did in Florida. Well, and let's talk about how things turned out. Not so good for everybody involved. So in a heartbreaking escalation from a routine school encounter, a 15-year-old Florida student allegedly shot and killed his 16-year-old classmate following a refusal to apologize for a shoulder bump in the hallway. This is all according to the arrest affidavit. Now, the incident took place at the Oak Ridge High School in Orlando, and obviously raises some profound questions about accountability, not only for the young perpetrator, but potentially for his parents, given the unresolved mystery of how he obtained the gun. Jacori, Jacori Redding, a sophomore, stands accused of fatally shooting Pinion, Pinen, Dalmace on October 9th near the school campus. What began as a minor physical contact during the school day quickly spiraled into violence when Dalmace demanded an apology, which Redding declined to do. The two reportedly agreed to settle the dispute with a fight at the adjacent basketball court. Now, according to police, Redding arrived at the park armed and discharged his weapon, striking Dalmace twice. The victim succumbed to his injuries, transformed an ordinary adolescent disagreement into an irreversible tragedy. Orange County Sheriff John Mina expressed deep frustration during a press conference on October 10th, stating it is profoundly disturbing that an everyday occurrence like accidentally brushing against somebody in a school corridor, something that many of us have all experienced, right? Maybe imagine brushing up against somebody in the mall by accident, or you bump and whatever. And then next thing you know, you're going to be shooting at people. Anyway, this loss was entirely avoidable. Yet a 15-year-old armed with a gun chose to irrevocably alter lives. Now, Redding faces serious charges, including manslaughter, unlawful possession of a firearm on school premises, and possession of a firearm by a juvenile. Police have affirmed that he is being prosecuted as an adult, and he was apprehended shortly after the incident. Discovered it in the school cafeteria in the weapon concealed in his backpack. Their police are still probing the source of the gun, a detail that ignited debate over parental responsibility. In light of Redding's access to the deadly weapon, experts and community advocates are questioning whether his guardians should be held accountable under the laws addressing negligent storage or supervision of firearms. Florida statutes allow for charges against adults who fail to secure weapons for minors, potentially leading to the misdemeanor or felony penalties. Now, while no such charges have been filed yet, the case echoes similar national incidents where parental oversight has come under some scrutiny, prompting calls for stricter enforcement to prevent youth access to guns. Well, the preliminary findings suggest that no prior animosity between these students existed and that the event is profoundly regrettable. The sheriff also noted that these were both sophomores with promising futures ahead. Anyway, the court documents also note that there's a pending case for grand theft by Mr. Redding regarding auto theft, and he has a record of some 39 disciplinary actions at school, with at least 17 involving physical confrontation, such as fights and assaults. Analysis of the mobile device uncovered messages indicating a pattern of discussing firearms and violent intentions, including texts from July hinting at anticipated conflicts. A witness also reported Redding displayed what appeared to be a gang-related hand signal and maintained a composed demeanor during the altercation. Now, during a juvenile court appearance last Friday, Redding was ordered into detention. His relatives present in the courtroom voiced their support with calls of affection. A subsequent pretrial hearing was held on Wednesday, though additional details remain undisclosed by the Orange County Corrections Department. Obviously, bigger concerns here about gun accessibility, role of parents, vigilance, and what's going on. The school, right? Why shouldn't the school be held accountable as well? You've got a thug that has 17 prior incidents of violence, apparently potentially a gang member. My goodness. Shouldn't we be charging everybody? I don't know. I just don't know anymore, ladies and gentlemen. But kids do stupid things. They should be tried as adults. I hate to say it. I know all the studies, the brain doesn't develop for children. They shouldn't make any real decisions until they're like 21 or 25. But that's not the world we live in. These kids know the difference between right and wrong. And stupid cases like this. I had a murder case. My gosh, it was so many years ago. But all I remember was going to be a fight between a couple kids who went to a school together, and they were at a house party. My client, little gangbanger. The other kid, football player, going to go to college, probably have a great life. They have some disagreement, something like bumping into each other, and they say, let's go upstairs and we're going to have a fight. Everybody gathers around. The football player kid takes off his jacket, getting ready to fight. They get a fisticuffs. My client then pulls out a gun and shoots the football player directly in the chest in front of about, 65 witnesses. Make a long story short, client flees to Oregon, commits another homicide where he was convicted by a jury of his peers. They ultimately bring him back to Colorado, where he is promptly convicted. And, the funny thing was the first trial, we mistried. And then, of course, they fixed any issues that they had second time around. But it just goes to show you how ridiculous this is. Now, this kid was a juvenile when he was tried, but as an adult. But the event took place when he was a juvenile. And so under the juvenile life without parole from the United States Supreme Court, he has to be eligible after 40 years. But he was an adult when he did the one in Oregon as well. So tough circumstances, man. Kids should do nothing other than go to school, go home and do homework, and shouldn't be out at parties where there's not like real adult supervision. And I say that somewhat jokingly because we've all done it, right? But it's such a dangerous world, much more dangerous than it ever used to be. Next on the docket, Alec Murdaugh. Well, he doesn't like the Hulu story of his life. So in a little plot twist worthy of its own scripted drama, the infamous South Carolina lawyer Alec Murdaugh, currently serving life sentences for turning family night into a shotgun horror show, is firing back at Hulu's latest binge-worthy obsession. The 8-episode limited series, cheekily titled Murdaugh, Death in the Family, rehashes his spectacular downfall from legal eagle to convicted killer. But Murdaugh isn't applauding this series from his cell. His legal squad dropped a scathing statement declaring Murdaugh deeply disappointed and disturbed by the show's flashy spin on his clan's calamity. The claim, it's riddled with fibs and fabrications that warp the truth about his bonds with his wife, Maggie, and son, Paul. Folks, he insists he cherished more than his alleged pilfered millions. The show's got more holes than a low-country mosquito net, the statement essentially snarks, pointing out how it mangles their family vibes. And here's the kicker. Nobody from Hulu bothered to slide into the DMs of the Murdaughs, his surviving son Buster, or any kin or counsel for a reality check. Instead, it leans on juicy gossip from outsiders who wouldn't know a Murdaugh from a muskrat. Hulu, playing coy, hasn't piped up to any questions yet. But, quick little flashback. June 7th, 2021, Murdaugh dials 911 in hysterics, claiming he stumbled upon Maggie and Paul gunned down by the dog kennels on their sprawling hunting grounds. But, oh, how the mighty fall. Soon his web of financial shenanigans unraveled, revealing he siphoned off fortunes from his clients to fuel a painkiller habit that could rival a rock star. It's tough for folks to wrap their heads around how someone can be Dr. Jekyll in the office and Mr. Hyde at home, quipped Mark Tinsley, a lawyer who took the stand against Murdaugh, chatting with some news reporters, some still citing that the polished facade like it's gospel. Fast forward, March 2023, a jury slaps Murdaugh with double life terms for murder, plus a cherry on top of 40 years for his money mischief. He's now cooling his heels in the max security South Carolina slammer as the series hooks viewers with its glossy take on one of America's juiciest true crime sagas. Murdaugh's camp is basically begging fans to put on their skeptic specs. Treat this like a tall tale at a bar, they advise, not the unvarnished truth about Alex, his loved ones, or the nightmare that it's amps up for clicks. So let's be frank, ladies and gentlemen, I haven't seen this one yet. I know it's been out. I think I'm going to try to watch it. I'm waiting for some bad weather to binge watch this. We started following that Murdaugh story from the beginning. As you know, Beaufort, my adopted hometown. I loved that place. I was stationed down there, got a home down there. And I knew as soon as the Murdaugh, there was that boat accident, we kept following the story. People thought, what is this story? It's not going to go anywhere. And then it turned out, well, here we are today. Just saying. Next on the docket, a former American Idol participant charged with multiple felonies, including a couple involving some minors. So a former contestant from the television program American Idol, a guy by the name of Randy Madden, has been arrested on allegations of engaging in sexual activities with an individual under the age of majority. That's 18 for people if they don't know. Anyway, Mr. Madden, who is 45, faces 6 felony counts related to the incidents. And these include charges of oral copulation with a person under the age of 18 years of age, unlawful sexual intercourse, penetration with a foreign object involving anal and genital areas, distribution of harmful material, enticement, and attempting to prevent a witness from notifying law enforcement. That's probably something along the lines of, if you go to the police, we're both going to go to prison. My life will be over. Anyway, the age of the alleged victim has not been disclosed as of yet, but court records from Ventura County, California indicate that the charges stem from at least one purported encounter that occurred between July and September of this year. Madden was formally charged on Monday, entering a plea of not guilty to all the accusations, and was subsequently detained. Police confirmed that Madden secured his release by posting a $100,000 bond on Tuesday. Now, viewers of American Idol may recall Madden from the show's 8th season, during which he auditioned in Phoenix, Arizona, performing Bon Jovi's "Living on a Prayer." He received unanimous rejection from the 4 judges and did not advance to the competition. But efforts to obtain a statement from Madden have been unsuccessful thus far. Next on the docket, this day in legal history. November 5th, 1862, over 300 Dakota men are sentenced to death following a mass trial after the U.S. Dakota War, marking the largest mass execution in U.S. history. Now, these people were commuted by Lincoln for most of it. Anyway, it obviously highlights a little bit of problem with due process and failures and federal treaty violations with the Indians under the Fifth Amendment. But hey, bygones, I guess, right? 300 people mass executed. November 5th, 1872. Women's rights advocate Susan B. Anthony illegally cast her vote in New York congressional district election. She ultimately went to trial and was fined $100. On November 5th, 2006, the former president of Iraq, Saddam Hussein, ever heard of him? Sentenced to death by hanging for crimes against humanity during his time in office or ruler of Iraq. Next, our quote of the day: success is not final. Failure is not fatal. It is the courage to continue that counts. Good words to live by, particularly if you're a criminal defense attorney. And that was by Winston Churchill, just to be clear that we didn't plagiarize anything. And next, our dumb criminal of the day. So, in a little bit of a plot twist that's sure to leave aviation enthusiasts chuckling, a Connecticut couple accused of turning a routine JetBlue jaunt into an impromptu adult show have been cleared for takeoff, legally speaking, that is. Court records revealed that the felony charges against the amorous duo have been jettisoned faster than a bumpy landing. Trista Riley, who's 43, a medical receptionist with a knack for hands-on work, and her husband, Christopher Arnold, a general contractor who's no stranger to building tensions, were nabbed back in July for what police dubbed as a lewd or lascivious exhibition aboard Flight 163 from New York JFK to sunny Sarasota, Florida. But as of October 30th, prosecutors have opted to bail on the case, leaving the pair free to roam the friendly skies without a criminal cloud overhead. The mid-air mischief reportedly kicked off during takeoff when a fellow passenger traveling with her two wide-eyed youngsters spotted Riley allegedly lending her companion a helping hand, so to speak, in the literal sense. Not content with mere manual labor, the witness claimed the scene escalated to something resembling an in-flight oral presentation, all while the kids gawked from nearby seats. They didn't even pause for the seatbelt sign, apparently, the mom told the police upon arrival, turning what should have been a family-friendly voyage into an unexpected R-rated spectacle. Enter JetBlue's flight attendant, Brian Zepp, who swooped in like a caped crusader of cabin decorum. He confirmed spotting Riley in a compromising position, head down in Arnold's lap, bobbing away in row 25 as multiple young passengers and their mothers bore unwilling witness to the high-altitude hijinks. Police reports later corroborated that underage onlookers had caught sight of the explicit escapade, prompting the couple's arrest upon touchdown by the Sarasota Airport Authority police officers. Initially released on their own recognizance pending a jurisdictional probe because nothing says romantic getaways like debating federal airspace laws. Anyway, the case fizzled out without fanfare. The filings offer no juicy details on why the charges were dropped, though whispers of legal loopholes over where exactly the mile-high magic happened might have played a role. As for whether Riley and Arnold will grace JetBlue's aisles again, that is up in the air. One thing's certain, though, next time they fly, they might want to stick to their in-flight entertainment menu. After all, not every journey needs to end with a bang, or in this case, begin with one. It probably had nothing to do with jurisdiction. Under federal law, they can charge you basically where you land. Been there, done that. Not with me personally, but I've represented people. Had a case in Charleston where a guy was doing some various exhibition things on an airplane and maybe urinating as well. Anyway, loved going to Charleston. That was great. To go to court, got a great disposition. But this particular case, it was more than likely that nobody saw any adult pieces and parts. And that's really what you need. People have to actually see you engaging, actually see the parts, so to speak. So that's probably why the case got dismissed. So to our Mile High Club people, congratulations, you made it. And you didn't get charged. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. Remember, the Constitution matters.